Hello, everyone, and welcome to today's Vistage webinar. Before we begin, I'd like to go over some items to help you participate in today's webinar. If you're experiencing technical difficulties joining the webinar, please dial support at 888-259-8414. When you join today's webinar, you selected to join either by phone call or computer audio. If for any reason you'd like to change your selection, you can do so by accessing your audio pane in the GoToWebinar control panel. During the presentation, all participants will be in listen-only mode. You're invited to submit a question through the questions pane in the control panel to the right side of your screen. A recording of this presentation will be sent to attendees via email in 24 hours. I would now like to introduce the moderator for today's webinar, Ann Petrick, Senior Director of Research at Vistage Worldwide. Over to you, Ann.
Thank you so much, and welcome everyone to Asset Protection in the Age of Coronavirus. And as we all continue to navigate through these unsettling times, it's more important now than ever to ensure that you and your assets are protected. In reaction to the financial stresses, people and businesses will be much quicker to resort to litigation to recoup monies owed or avoid taking financial losses. So today we have two experts from Presser Law Firm who will offer strategies to protect yourself before trouble arises. Hillel Presser and Ariel Enisman, who are frequent speakers at Vistage events. They deliver insights on asset protection planning to help business owners and key executives implement strategies to protect every single personal and business asset that you own from any and all financial threats. So if you like what you hear, they're offering virtual sessions to Vistage groups. Now, the Presser Law Firm is a nationwide asset protection law firm specializing in helping both individuals and businesses in connection with the establishment of comprehensive asset protection plans. And these incorporate both domestic and international components. So to introduce our speakers, Ariel is an attorney at the Presser Law Firm and holds a law degree from Nova Southeastern University Law School, as well as a bachelor degree in business administration from the University of Miami. She's a member of the National Speakers Association and very active in a number of professional advisory committees throughout South Florida. Ariel also recently received an award for Women of the Year for the Leukemia and Lymphoma Society, which she raised funds for blood cancer research in honor of local children who are blood cancer survivors. And that's a cause near and dear to my heart, as I've been involved in that as well. So congratulations, Ariel. And Hillel Presser is the founder and managing partner of Presser Law Firm and a Vistage member. He represents individuals and businesses in connection with the establishment of comprehensive asset protection plans that incorporate both domestic and international components. Hillel has been featured in media internationally, including Forbes, Sports Illustrated, and The Robb Report, and various network television stations. He has also represented today's most well-known business owners, doctors, celebrities, and professional athletes. He has also authored several books on asset protection and law, including Asset Protection Secrets and Financial Self-Defense. And at the end of the presentation, we'll tell you how you can request to have these books sent to you, as well as request a complimentary consultation. So now over to you, Hillel, to get us started.
Thank you, and good afternoon. I'm going to try and go a little bit fast on the introduction, talking about why we need asset protection so much, why liability insurance is great, but why it might not be enough, and why we really need asset protection planning with everything that's going on with coronavirus. That way we can get to the meat and potatoes. But without further ado, let's just get started. I showed this screen just to kind of let everyone know that lawsuits are everywhere. When you have a pandemic like coronavirus or any financial uncertainty where people are losing money, people are losing their jobs, business owners are going out of business. And unfortunately, when everybody is in need and desperate for money, that's when litigation happens. So if you think litigation is bad now, give it a few months and have the unemployment rate keep going up. It gets worse and worse because people get desperate and they really have no other choice. So lawsuits and litigation really becomes a business. So what is asset protection? Asset protection is the legal process of titling both your personal and business assets to put them beyond the reach of future potential threats and creditors. And what you want to do from an asset protection point of view is you want to make it so difficult and expensive if not impossible, for anybody to collect against you, they don't want to sue you in the first place. So you don't want to be the low-hanging fruit. And with all these breach of contract claims that are going to happen, with all the short sale and foreclosure deficiencies that are going to happen, with all the employee lawsuits that are going to happen, you want to make sure that you're the 1% who's protected your personal and business assets. So either A, you don't get sued in the first place and people move on to the next candidate, or you settle your case quickly for 5 or 10 cents on the dollar. And a lot of business owners always ask, do I have enough to protect myself? And the short answer is yes. And more importantly, the less you have or the less you think you have, the more important asset protection becomes. I always like to give an example. Take one of my professional athlete clients who signs a contract for $40 million. Well, if they get sued for $5 million, they still have $35 million left. Take the average person who saved up a couple $100,000 or $1 million over their career. Well, if they get sued for $1 million or $2 million or $3 million, they're wiped out. So the less you have, the more important the protection becomes. And so many people say, well, what if I already have a plan? And if you already have a plan, that's fantastic. But understand that every year your assets change, every year the laws change. And probably one of the biggest misconceptions that I see on a daily basis talking to clients is that people have a great estate plan. So they have a trust or they have a will. And for some reason, they think this gives them asset protection. Most trusts won't give you any asset protection. So a lot of people think they have a great asset protection plan when in turn, they just have a great estate plan. So why do you even need asset protection? Essentially, like I said, in today's economy, lawsuits are going to go up and up. And I put this little cute cartoon over to the right. It's two lawyers talking. One says, I say sue. The other one says anyone in particular. And people always laugh when they see this, but I can tell you what's going on right now. The lawyers are getting together and they're talking about how can we make money from what's going on? Who can we sue? What are we going to be able to do to put money in our pocket? Which I don't think is right to benefit from this type of thing, but we need to be prepared for it. There's over 100 million lawsuits every single year, and that number is only growing. Lawsuits have literally become the next biggest business. There's a 1 in 4 chance that you will be sued in the next 12 months. The average person and business gets sued 5 times over their lifetime. And I normally say there's a 50% chance of divorce, and maybe I'll make a bad joke. But with quarantine going on, there might be a 99.9% chance of divorce. And also, a lawsuit can cost you tens of thousands of dollars even if you win the case. So it's not even whether or not you win the case. It's you could spend hundreds of thousands of dollars trying to defend yourself. And if you win, you've really lost because you've spent so much money. So the point is that the trick is not making money, it's keeping it. And the challenge I give being a Vistage member to all other Vistage members, because we're so worried about growth, is for every 60 minutes you spend making money, stop and spend 60 seconds thinking about how to protect it. So everybody talks about insurance and they say, isn't this why I have insurance? And let me preface this by saying I like insurance. I advise my clients to buy as much insurance as they can because it's cheap and it helps you sleep at night. But understand that insurance companies are the most profitable industries in the world, and that's not because they pay every claim. They take in as much money as they can, and they don't want to pay anything out. You may have a $300,000 insurance policy. If you get sued for $1 million, you need to pay the difference. In these times, you never know. Your insurance company might go bankrupt. And if anyone's ever read their insurance policy, which I know most people don't, there's about a half a page of what's covered and 50 pages of exclusions. My father used to tell me growing up, he'd say, son, the big print giveth, the small print taketh away. And, just this week, I own about maybe, 30 or 40 properties. I called my insurance company. I have loss of rent insurance. Well, they pointed me to, I'm just making it up, page 37, subsection 2, and in 4-point font. Unfortunately, the renter's insurance doesn't cover it because the building's still there. So the fact that there's a financial crisis going on, you cannot collect on your loss of rent insurance. I have a mold claim where someone said they got sick in one of my places. I have a $10 million umbrella. Pointed to page 25, subsection 3, 4-point font. Mold's only covered up to $5,000. So a lot of people think insurance is great, but understand that there's a reason why a $5 million umbrella only costs you $1,000 or $2,000. So my point is that, look, insurance is great. I'm not telling you to get rid of it, but insurance alone is not the answer. You want to supplement your insurance with an asset protection plan. I call it the belt and suspenders approach. I like insurance because they'll always pay the lawyers to fight your claim, but you really need an asset protection plan to really defend yourself from the lawsuit. 3 maxims of asset protection. Number 1, just make sure you're proactive. Protect yourself before you have a problem. You need the asset protection before you get sued. No different than needing the car insurance before an accident, the life insurance before death, the health insurance before you get sick. Start with a basic plan and add firewalls as needed. Look, I try and tell clients, start off very simple, start off very inexpensive. As your assets grow, your plan can grow. As your education grows, your plan can grow. Start off with the most important assets like your business, your money, your real estate, et cetera, et cetera. And most importantly, don't look for one magic bullet. Asset protection is not cookie cutter. Everybody has different assets. Everybody has different potential threats and creditors and liabilities. So everybody really needs an individualized and customized and tailored plan that's going to fit both their personal and business specific needs. I think now is a really good time in this economy to do a financial checkup. You should really list all your assets. If you email us, and Ariel will tell you exactly how to do it, we can actually send you an inventory list. It lists every asset, stuff that you probably won't even think about, arts, antiques, furniture, money owed, et cetera, et cetera. And now's a really good time to say, what do you have? On the other hand, you want to list all of your liabilities. Who's the creditor? How much is owed? And who's responsible? So did the business sign on the loan? Did you personally guarantee? Did the company sign on the mortgage? Did you personally guarantee? And what personal and business assets do you have to keep you guys safe for the next 3 to 6 months? Now, I hope it's 3 to 6 months, but I really like to look probably for the next 12 months. And once you inventory what you have, once you figure out what your potential liabilities are, then you can decide, okay, how do you want to allocate them? Obviously, things like shelter and food and things like that come first. But after that, you don't want to lose the business that you built. And we'll talk about that a little bit later on today. 5 biggest mistakes to avoid. Number 1 is hiding your assets. Asset protection is not about hiding. It's not about secrecy. It's about protection. And with a good asset protection plan, you should be able to tell everybody what you have, where it is. They just shouldn't be able to get to it. You never want to title your assets to straws. That means giving your assets to your friend or someone else who you believe has less financial trouble than you. I can guarantee you, I've seen it time and time again. Those people end up having a lot more liabilities than you think, and you end up losing your assets to their liabilities. You don't want to go shoving everything in your spouse's name. Like I said, there's a 50% chance or more of divorce. And even if you have a happy marriage, you could be messing things up from an estate tax perspective. You never want to commit fraudulent transfers, which means you want to be proactive. And you never want to break any laws. You want to keep it legal and ethical. So hopefully by now I've laid a little bit of a foundation about what asset protection is, why it's so important, why liability insurance is great, but why it won't be enough. And especially in this economy, how, again, lawsuits, and you'll probably start seeing them in the next few months, are really just going to explode. If you think they're bad now, unfortunately, they're going to get a lot worse. At this point, I'm going to turn the presentation over to attorney Ariel Enisman, and she's going to tell you exactly how to protect all your personal and business assets so you know exactly what to do.
So this slide is really, really important because it's going to talk about your basic strategies. In the middle of this slide here, we have what's called exposed wealth. And exposed wealth simply means any asset that is in your personal name is exposed because if you're sued, you can lose it. So I want everyone listening to think to themselves for a minute, do you own any real estate in your personal name or in your living revocable trust? Well, if you do, it's exposed, and if you're sued, you can lose it. I want you to think to yourself, do you own any shares in a corporation in your personal name? Well, if you do, they're exposed, and if you're sued, you can lose them. And lastly, I want you to think to yourself, do you own any liquid assets, stocks, bonds, money markets, savings accounts in your personal name or in a living revocable trust? And if you do, you can probably guess what I'm going to say, but they're exposed, and if you're sued, you can lose them. So what do? We have a few strategies here. The first one is transfer to a protective entity. And I'm sure most of you have heard of different types of protective entities, LLCs, limited partnerships, S corporations, C corporations, different types of trusts. And the way that it works is interesting. Each one of the people on this phone has their own social security number, and they're their own separate individual. So let's just say I get sued and I'm a separate individual. Well, no one can come after you guys listening, and vice versa. If you guys get sued, no one can come after me. Well, it works the same with your protective entity. Your protective entity gets a tax ID number, which is like a social security number for an entity. And the law literally looks at you and your protective entity as two separate individuals. So if someone sues you, they can't come after your protective entity. And if someone sues your protective entity, they can't come after you. I don't make up the laws, I just follow them. So take it for what it is. This is what the law says. So now if you're thinking about those exposed assets that are in your personal name that I just mentioned, well, why not take them out of your personal name and move them to protective entities? So now if you get sued, nobody can take them from you. And I'm just going to spend a few minutes here discussing a few protective entities and a few different strategies with some different assets. One of the first ones I asked about was real estate. So I want you to think to yourself, if you own any real estate other than your primary home, so a vacation property, a rental property, a commercial building, piece of land in your personal name. So like I said, it's exposed. So one of the first things we'll want to do is transfer that to a protective entity. Now, it might be an LLC, it might be some other type of entity, but an LLC is a pretty common entity to use. And there's two reasons why you'd want to do that. Reason number one is if you own the property in your personal name today and you get sued personally, well, that is an asset of yours. So now someone could take your piece of property. So if you get into a car accident, if you have a breach of contract, if, like I said, if someone sues you personally, they can take your property from you. The second reason is if somebody gets injured on your property, so you have a party, you've got a rental property, you've got a commercial building, an employee slips and falls, well, the owner of the property is liable. So if you own the property in your personal name today and somebody gets injured on your property, now personally you'll be liable. So by putting it into an LLC or any other type of protective entity, we're going to get rid of both of those issues. Issue number one, well, if you're sued personally, car accident, whatever it might be, well, now you'll no longer own the piece of property. It's owned by the protective entity. So now, if you get sued, nobody can take the piece of property. And number two, if somebody gets injured on the property, they slip and fall, something happens, well, the owner of the property is liable. Again, now, by putting it in the LLC or the protective entity, you'll no longer own the property, so personally you won't be liable. So the protective entity would be liable. And our recommendation would be to, limit the amount of assets that you put into each protective entity. That way you limit the exposure and you limit the dollar amount. Another use for protective entities would be, your business. And I know a lot of people are very concerned about their business right now. So some of the strategies that we would think about are, does your operating company have multiple divisions? Because having one operating company today is not necessarily good enough. Because if you're running multiple divisions or you've got different locations, well, if something goes wrong with one of those divisions or something happens in one of those locations or with what's going on right now, maybe one of your divisions is suffering, but the other part of your business is not. Well, if you have it all operating under one company, now your whole business is at risk. So you want to consider potentially separating out your different business divisions, separating out the winners from the losers, separating out the liabilities. And even more so than that is to also think about, what assets are in your operating company. And I'm not getting into great detail today, but I just want you to think about, the different assets within the company, the different divisions, and we want to limit the exposure, like we said, as much as possible. That way you're never the low-hanging fruit or the easy target. And the same goes for any liquid assets. So if you have any stocks, bonds, money markets, savings accounts, well, like I mentioned, if they're in your personal name today, they're exposed and you can lose them. So you want to consider, putting those assets into a protective entity where now if you get sued, nobody can take them. And those are just a few assets, and I tried to pick the ones that I know people will be most concerned about, especially in light of what's going on today, liquid assets, the businesses, and a lot of times people are also, we see some issues now with rental and investment properties. The second strategy I have up here is protecting with liens. So using liens, mortgages, encumbrances to actually make your assets look as valueless as possible. It sounds backwards, but poverty is power. You know, if you think about it, what's $1 million house worth if you owe $950,000 on it? Or what's a $40,000 car worth if you owe $35,000 on it? So you'll want to use liens, mortgages, encumbrances to make your assets look as valueless as possible. Number one, our goal would be to discourage lawsuits. When someone does an asset search, you strip the value out, you've stripped the equity out. And number two, the banks or the financial institutions will always be the first creditor in line. So you can do this both from a personal standpoint, you can do this from a business standpoint. Might want to look into this now in regards to, a lot of businesses, that are having cash flow issues. Not only people might be concerned about debt, but it could actually help you from an asset protection standpoint as well. The third strategy I put up here is convert into exempt assets. And exempt assets simply mean assets that are exempt by state law. So each state has different exemption laws, and each state says if you put your assets in these certain places or you use these certain vehicles, then your assets will be protected by state law. Now, I encourage each of you to look at your state, and you can do so by going to our website, which is www.assetprotectionattorneys.com. And on the left-hand side, you'll see a button that says Financial Planning Exemptions. If you click on that, you'll then see each state listed, and you can determine what's exempt in each state. And I'll cover that in a little bit more detail in the next slide, just to give you an idea of some of the assets that may or may not be exempt. But again, you can look at your state individually. And the last strategy that I have up here before I move on to some other things is transfer all ownership rights. And this deals with one of the keys of asset protection, which is own nothing, control everything. Own nothing, control everything. Because if you think about it, if you own something, well, if you're sued, you can lose it. So you really want to start to focus on who controls the assets and who benefits from the assets. And it's a bit of a mentality shift because your whole life you're taught buy, own, accumulate. But really what you want to be concerned about is the control and the benefit of the asset rather than so much who actually owns the asset. So just to give you an idea of some of the most common exempt assets, the home. Certain states will protect your home up to a certain dollar amount. Retirement accounts, so IRAs, 401ks, pensions, qualified plans. Certain states will also protect your retirement accounts. No different with the protection through annuities as well as life insurance. Those are the most common exemption laws that we see. So like I said, if you go to our website, you'll be able to see what's protected in your state. And the cool thing about this is that it will give you a roadmap. So not to say that necessarily one state has better laws than another, but if you use this as a roadmap, it might help you determine where you do and maybe where you do and don't want to put your assets. For example, if your home is totally protected in one state, well, maybe you can pay off your mortgage or, no, it doesn't really matter because no one can take your house. Well, certain states, your home is only protected up to a few $1,000s. So if you live in that state, well, maybe you want to use one of our other strategies where you protect with liens, mortgages, or encumbrances. Or depending on what state you live in, you want to see if your retirement is fully protected. We're not your financial advisors. Our goal is to work with your entire financial team so that you have a comprehensive plan. But, you could work with your financial advisor to maybe determine where you do and don't want to put your money based on what state law is saying. So it's a way to give yourself a roadmap. Tenancy by entireties is a way to title assets for living married spouses. So again, this is recognized, it's a state-by-state law. It's recognized in 25 states. You can again go to our website, assetprotectionattorneys.com, and on that left-hand side, you'll also see a button that says tenancy by entirety, and you can see if this is recognized in your state or not. And what tenancy by entirety states is that the assets of both spouses are not subject to the creditor of one spouse. So, for example, if spouse number one has $100,000 in their personal name and they're sued, well, they can lose it. And if spouse two has $100,000 in their personal name and they're sued, well, they can lose it. So if spouse one and spouse two each take their $100,000 and they put it into an account together labeled tenancy by entireties, well, now if spouse one is sued, they can't touch a penny. And if spouse two is sued, they can't touch a penny. The only way a creditor can come after these assets are if both spouses are sued for the same cause of action, which usually happens much less frequently than one spouse being sued individually. So like I said, it's another way to title assets. It doesn't cost you anything to own assets tenancy by entirety. It is only available for spouses that are currently married and living, and it will give you a great extra layer of protection. Just one thing to be mindful of is upon death or divorce, there is immediate exposure to the assets. So it's not the only thing you'd want to do to protect yourself, but it's a great extra layer of protection that you can get at really no additional cost. With what's going on right now in regards to the economy and with coronavirus, now is a really good time to reevaluate your business. So, one of the things that a few of the questions we've told our clients to take a look at is, can your business survive with little to no revenue within the next 1 to 6 months? As Hillel mentioned earlier, you probably want to look at, the next 12 months, but certainly taking a short-term look is a place to start. Can you retain your employees or should you lay them off? Can you develop a new source of revenue with your current business? With every, obstacle comes some sort of solution and opportunity. So, what are those new business opportunities that you can make of this bad timing? So really taking a look at your current business and what you have now, can you survive the next few months? And certainly, what are you going to do to create new opportunities and new sources of revenue? While we're talking about corporations, one of the big misconceptions that we see in our practice is, the way that people own their corporations. And one of the most important things for people to think about is not only just the asset protection, but also having a comprehensive plan. So not only looking at things from an asset protection standpoint, but also a tax standpoint and a business succession standpoint and an estate planning standpoint. So corporations are great to protect yourself from bad business debt. If something happens in the business, personally, you're not liable, which is probably why anybody on this phone call has set up a corporation to start. The bad thing about corporations, S corporations, C corporations, is they're bad to protect your personal assets. Because if you own shares in a corporation in your personal name, so if you own S corporation shares or if you own C corporation shares in your personal name, well, that is a personal asset of yours. And like I mentioned earlier, it's exposed, and if you're sued, you can potentially lose them. And if you own the majority of a company's shares in your personal name and you get sued and someone takes more than 51% of the shares in a corporation, well, now they can hire, they can fire, they can liquidate bank accounts. So it's important to think about how to protect the shares in your corporation. And many people like to set up S corporations for tax purposes. However, S corporations from an asset protection standpoint is probably one of the worst entities to have because the IRS has restricted who can own shares in an S corporation. So it becomes a little bit more difficult to protect. Now, don't worry, there are solutions to every problem. So there's ways that you can protect C corporation shares. There's ways that you can protect S corporation shares. There's ways that you can protect interest in any other type of protective entity. So there's simple ways to protect it as well, but you really want to think about how you own your company. So if you own shares in your personal name, we'll want to talk about how to protect those. I'm just going to talk about international asset protection briefly. So far, we've been talking about domestic strategies, and domestically inside the United States, you can get about 80, 85, 90% protected, which is great because most of the time a client will come to us and they'll be somewhere between 0 and 15% protected. So to go to 80, 90% is really, really great. However, sometimes the laws in the U.S. are a little bit gray. Sometimes judges rule based on emotion, and sometimes we just don't know what's going to happen. So if a client wants more protection, we'll use international strategies. And I'm just going to take a few minutes or so to give you guys an example of what someone would need to do to go after one of our clients who's put their funds into an international protective entity. The first thing that someone would need to do is sue my client and beat them in the United States. Because if they don't sue them and beat them in the U.S., legally, our clients don't have to tell you where their assets are. But you sue my client in the United States, you sit them down for deposition, hopefully you hire a really good attorney that knows the right questions to ask, and you find out that our client has a trust in, call it the Cook Islands. There's several different jurisdictions, but there was just a recent article in the Cook Islands, so I'll use that as an example. I'm not sure if anyone on the phone has been to the Cook Islands recently, but the last time I checked, there's about 1 or 2 flights a week from California. It's a 15-hour flight, and you're stuck there for a week. So you fly to the Cook Islands, you've got this U.S. judgment, you're ready to collect against our client, and quickly the judge crumples it up, throws it in the garbage because they don't recognize U.S. judgments. So now you'll need to relitigate the entire case in the Cook Islands. So you'll go to hire an attorney, which you think might be easy because it's easy to hire an attorney in the United States, and you'll quickly find out that the 4 or 5 attorneys in the Cook Island are all conflicted off the case because they work with the attorneys like myself or the other trust companies. So now you'll go to fly to the closest country, call it New Zealand, and again, you'll try to easily find an attorney. And you'll find out that where we set up these international entities, they don't recognize contingency fees. So now you will need to pay your U.S. attorney hourly and your New Zealand attorney hourly to fly back and forth to the Cook Islands to relitigate the entire case. All of this has to happen within the statute of limitations, which is anywhere between 0 and 2 years. So that means your U.S. case had to take less than 2 years for you to even be eligible to sue. And anyone involved in a lawsuit knows that's probably not happening, but you've got the fastest U.S. case, you've got both your attorneys, you're there, you're ready to sue. Well, your attorneys have to prove the case beyond a reasonable doubt, which means they need more evidence to collect the money from an international entity than they needed to put Casey Anthony in jail. You can't get any punitive damages. So although you might be able to collect for the actual cost of an accident, you can't get the pain and suffering or the real, the large amount of assets. And lastly, any good asset protection attorney, and we'll put in our 150-page trust agreement, what's called a CUBA or a flee clause, which allows us to relocate the assets at any time. So while this whole thing is happening in the Cook Islands, you can move the assets to Nevis, Belize, Switzerland. A creditor will have to do the whole thing all over again. The point is that it's very, very difficult, if not impossible, to collect the assets from an international entity. That, this is really the end-all, be-all. I'll never call it 100%, but I'd call it, you could probably get 99.9% protected. Estate planning is really, really important, especially now with what's going on. So like I just mentioned a few minutes ago, it's really important not only to look at things just from the asset protection, but also the tax and the estate planning point of view. And, with what's going on right now, it's really important to think about, kind of those end of life planning that you do. The stats are something I just was looking recently. Only about 4 out of 10 Americans have completed their estate planning. So that means the majority of people, have put this type of planning on the back burner. And it's really important that you do it, because unless you want your state to determine, where your assets are going to go, or more importantly, who's going to make medical decisions for you, who's going to take care of the kids if, God forbid, something happens to you, you must go do your estate planning. Our goal is to give you a comprehensive, integrated plan with both your estate planning and your asset protection. So, the asset protection piece, you protect everything today while you're alive. And now that you have something to leave after you pass away because you've protected it, you've automatically integrated in your estate planning. So you want to have a comprehensive, integrated plan. And the last thing I'm going to mention before I take questions is business succession planning. And so like I said, another piece of the puzzle is business succession. Everyone's worked hard. Everyone's, worked on protecting their business, growing their business, and, ultimately for what? And, that's the plan for the future, what's going to happen to your business. And so it's really, really important that you start to think about, what are your exit strategies? What's going to happen to your business in the future? One of the big common issues that we're seeing now is a lot of people got their businesses valued before, the coronavirus, and certainly how does that affect what's going on now? Or maybe they didn't value their business before coronavirus, and how does that affect it now? So you might have done it in the past. If you haven't, it's really necessary to start to think about your business succession plan. If you have done it, having it reviewed every few years, no different with your estate planning. If you haven't done it, you must go do it. If you have done it, having it reviewed every few years to make sure that you have the proper planning for yourself. And before we turn it over to you guys for questions, I'm just going to end on a funny note. I'm going to just talk about the 10 craziest lawsuits that were filed in the last few years. They were all real filed lawsuits. Number one, a couple sued an airline over a cockroach sighting. They stated that seeing cockroaches crawling out of the air vents caused them great distress and forced them to throw away all of their luggage. A woman sued a movie studio for not accurately portraying the movie in the trailers. She claimed it lacked being Fast and Furious. A fugitive sued his hostages for escaping, claimed they breached an oral contract when they escaped in the middle of the night, which led the fugitive to get shot in the back by authorities. A woman obtained walking directions which sent her down a highway. She followed the directions and walked in the middle of the road, got hit by a car, and sued for bad directions. An employee sued for wrongful termination because they helped customers during their lunch break instead of actually taking a lunch break. A wedding couple sued a photographer for wedding photos that didn't come out right. $4,100 as a refund and $48,000 to restage the entire wedding. A customer sued for being overcharged for sausage by 2 cents. They actually did win about $100. 2 children sued their mother for not spoiling them, claimed that she was a bad mom because she didn't send them college care packages and she haggled over dress budgets. She sued them. The children sued her for $50,000. A woman sued a police department for allegedly making her listen to Rush Limbaugh's radio show while she was handcuffed in the back of the police car. This last one on here, if there's any doctors on the phone, you'll find this one extremely, a man divorced and sued his wife for $120,000 and won for having ugly babies. She never disclosed that she had about a dozen plastic surgeries before she got married, and he claimed it was fraud. So I'm going to turn it over to you guys in a minute or so to answer any questions that you might have. Please feel free to ask anything that you have. Anyone that has, any additional questions that we don't get to today, or if you're interested in learning a little bit more about asset protection and how you can protect yourself today in light of what's going on, if you email info@assetprotectionattorneys.com, or you call the phone number on the screen here. We're happy to offer a complimentary consultation. So please feel free to do that as well.
Great. Thank you so much, Ariel. And let's get to some questions. And I'm glad we have so much time because we had a lot of questions. So I have got a couple first about insurance. So submitted in advance was someone has an insurance company that's not honoring the business loss income claim, though the agent provided documentation weeks ago that they were covered. What should they do in that case?
Yeah, unfortunately, I had the same issue personally. Like I said, the insurance companies love taking your money, but they hate paying premiums, and they always find a way not to. I mean, first you need to look at the contract and see what it says. My guess is that it's not just that they're not paying the claim; they're probably not paying the claim for a reason. So, for example, in my situation, I said, "Hey, you guys convinced me to have all this business interruption insurance and loss of rent insurance." Well, again, in the 90-page policy in 4-point font, they point you to one line where there's an exclusion that says, oh, if it's a worldwide disaster, if it's a not man-made, it has to deal with the earth, et cetera, et cetera, et cetera. It doesn't cover it. They'll try and claim that the building is still there, so you still have the ability to rent it out, and that unfortunately a financial disaster doesn't, be considered as one of the exclusions. Look, at the end of the day, if they should be paying the policy, which again, my bet is there's an exclusion, you can always sue the insurance company. The problem is it takes years and years and years. And the insurance company, a lot of times, not everyone, some of them are good and some pay, but the insurance company, their process is deny, 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 because they know people won't go to the work. Once you start suing them, then you have, they even think about paying. And, again, unfortunately, I've had the same issues myself. I had a mold issue in one of my rentals, had a $10 million liability. They pointed me to a $5,000 max, even though I had a $10 million liability. And I was driving my car not too long ago to Orlando. My tire blew out on the side of the road. I called my insurance company. They couldn't locate me, so they told me to wave down the next tow truck driver. I waved down the next tow truck driver. I took pictures of the tow truck driver. I took pictures of the tow truck. I took pictures of my car on the tow truck. I had text with the tow truck driver, but I could never get an actual receipt from him because I had to pay him in cash on the side of the road, and he didn't speak great English. And for months and months and months, fighting with my insurance company to get reimbursed $120, even though I paid them, $10,000 a year for God knows how many years for car insurance. So again, I'm not telling you to cancel your insurance. They do normally hire lawyers to fight your case and defend you, but you got to have an asset protection plan, and it's just really unfortunate what you're going through.
Thank you so much. We've had a number of questions that I know that you touched on, Ariel, about protecting the primary home or the primary residence, and there was a question about redoing a mortgage in an LLC and if that would protect the primary residence.
Yeah, thank you for that question. So in regards to putting your primary residence into an LLC, you'll want to ask yourself a few questions first, because if you put your primary residence in an LLC, you'll lose the potential $250,000 capital gains tax deduction per person when you go to sell your primary home. So, first you'll want to ask yourself, do you ever plan on selling your primary home? If the answer is you're not going to sell it, well then sure, we can consider putting that into an LLC. If you might sell it, you'll want to think about whether or not you're going to make a profit. And if you are going to make a profit, well, then you'll want to do, kind of a cost-benefit analysis as to the tax benefit versus the protection. So the reason I was talking about using protective entities for any assets other than your primary home is because there's no negative tax consequence to that. There just is that tax consequence for the primary home.
Okay, then to protect the primary home, your recommendation is?
So there's a few different things. One of the strategies would be to look at, what the exemption laws in your state are. So, if your home is exempt by state law, you don't need to do much. If your home is not exempt by state law, well, you might want to consider using that second strategy that we talked about, protecting with liens, mortgages, encumbrances. If you live in a state where tenancy by entirety is recognized, and you're married, well, you might want to consider, titling your home tenancy by entirety with your spouse, which will also give you another layer of protection. So there's a few different strategies. Those are, the common strategies, just to name a few of how you can protect your primary home. Excellent.
Thank you. And then there's some follow-on questions then about LLCs. So is an LLC not a personal asset if someone is sued? Does that relate to how many to shares, or is shares only related to S Corp and C Corp?
Really good question, and the answer is it depends on the state. So, for example, there's something called charging order protection, and that's a legal term, and essentially some states have charging order protection, some states don't. And charging order protection deals with, are your shares protected, are your shares not protected? So, for example, in most states, all of your C Corp shares, all of your S Corp shares are not protected. I say most states because Nevada has a little different law when it comes to shares than most other states. But in most states, all of your S Corp shares, all of your C Corp shares are totally unprotected. When it comes to LLCs, it really depends by law. So, for example, in Florida, there's charging order protection for multi-member LLCs. That means if I own an LLC with someone else, 50-50, 80-20, 99% and 1, my LLC shares are protected. However, in Florida, if I own an LLC 100%, then it's not protected. There's other states where it doesn't matter if you own 100%, if you have a partner, if you don't have a partner, where it may or may not be protected. So the answer is it just depends. And again, if they go to our website, it's assetprotectionattorneys.com. On the left-hand side, there's a button called Charging Order Protection. If they push the Charging Order Protection button and scroll down to their state, click on their state, it'll tell them if LLCs have charging order protection and if they're protected in their state. So again, it's just a state-by-state basis. Some protect them, some don't. And then some have special instructions like Florida, where they say if you own 100%, it's not protected, but if you have a partner, even for 0.5%, it is protected.
Excellent. Well, thank you so much. And there's a lot of questions about LLC, but it sounds like that varies by state. So we'll move on to some of the other questions. There's a question about, can attorneys search for all business bank accounts? So how exposed would all accounts be?
So the answer is it depends, and it depends how things are titled. It also depends, what kind of asset search they're doing. It's very tough, believe it or not, for someone to search and say, how much does John Smith or John Smith's business have in their bank account? That is a very, very difficult thing to do. Normally what happens when people are trying to go after people's bank accounts, whether they're personal or business, is they'll find out where the account is. They can find out where the account is either through due diligence, through litigation, if there's a financial affidavit under oath, depositions, court documents, etc. And then what they do is they'll try and freeze those accounts. So believe it or not, it's a lot of it has to deal with luck. I had somebody that I knew, and I told him, don't keep any money in your personal account. Don't keep any money in your personal account because he had a judgment. Well, what happened? The creditors froze his bank account. They happened to do it on the right day, and they got about $200,000-$300,000. So it's very tough. I'm not saying impossible, but very, very tough to find out specifically what someone has in their personal or business account. Again, they can ask you under oath if it's during a lawsuit, and you might have to respond. But absent that, it's really, really tough. And normally what creditors are doing is they're just freezing bank accounts, and they may or may not get lucky.
Okay, excellent. We have someone else who's asking, they're ending an 8-year period of litigation. Does it make sense for them to get all ready now, or would he face fraudulent transfer issues that would prohibit this?
So it depends on the definition of ending. If the lawsuit is over, then absolutely do your asset protection right away. Hopefully the 8-year lawsuit was an eye-opener. Hopefully that person can see the forest through the trees and they won't want to go through it again. If they would have had an asset protection plan set up, there's a good chance they could have avoided that litigation, or maybe they could have settled for 5 or 10 or 15 cents on the dollar, maybe after a year or two, but much quicker. If they're thinking about setting up an asset protection plan for that specific situation, it's probably going to be too late. A fraudulent transfer is when you try and do something after the fact and you're not proactive. So if they're doing it to protect from that lawsuit, then it could be unwound and the plan might be invalidated. However, there are other things they could potentially do. So for example, and again, it's state by state, but for example, and I'm just using Florida as an example, if someone's being sued and they have $1 million in the bank, that person can go put the $1 million into a house, and even though it's after the lawsuit, nobody can get it. Now, again, there's some very specific new detailed federal bankruptcy laws that say if you get pushed into involuntary bankruptcy and you haven't lived there for 3.5 years, then only part of it's protected. So you always need to cross the T's and dot the I's. But short answer is always do your asset protection. The more in advance you can do it, the more proactive you can be, the better protection you're going to have. Anytime you do it is probably better than nothing, but don't think you're going to get in a car accident, get sued, 2 years later you do it, and it's going to totally protect you. You just got to have reasonable expectations.
Okay, great. Thanks, Hillel. And I have another detailed question that I'm hoping you can answer. In the asset protection trust, if you put your stocks and personal assets into it, do you still stay as a trustee? And if you do, would a court then conclude that you're still liable because you merely set up this trust to avoid liability but retain control?
So the first question is, what is the person defining as an asset protection trust? There's irrevocable trusts where you irrevocably give away an asset, in this case, maybe your company, to a trust for the benefit of someone else. And that works. The problem is a lot of times people don't want to irrevocably give it away. When I hear the term asset protection trust, I feel like a client might be thinking about something that's called a DAPT, which is a domestic asset protection trust. They started off in about 5 states, went to 8 states, 13 states, 15 states. Now they're in a lot of states. The problem with the DAPTs, and I knew this from the beginning, they're blowing up all over the case, is that it's state law. So what if a client, lives in New York, they set up a DAPT in Delaware, but they have property in Florida? Well, whose law applies? Is it New York where they live? Is it Delaware where they set up the trust? Or is it Florida where they have property? If you have a trust in Delaware and I'm a Florida judge, I'm going to say, I don't care where your trust is. You have assets in Florida, I'm ruling over you. Or if you have a judge in New York, you live in New York, I'm ruling over you. Also, there's something called a full faith and credit clause, which is a federal law. Federal law trumps state law. And the full faith and credit clause states that a judgment against you in one state is good in all the other states. So if someone sues you in Florida and gets a judgment, they don't have to go sue you again in New York. So even if someone's using a asset protection trust law of a state, one thing a creditor can do is try and get the case removed to federal court, in which case the state law of the trust wouldn't apply. But to get back to the specific question, there's times where you can be the trustee. A time you could do it is maybe you have a third party set up the trust. So maybe you have your friend or your spouse or your father set up the trust. You're the trustee, and then you put the assets in. But if you want maximum protection, I like to tell clients no ownership, no control, which means you would not be the trustee. So again, I'm not saying there aren't ways you can do it, but for maximum protection, I don't love it.
Okay, great. So moving on from state questions, it sounds like a lot varies by state to international. If someone's setting up an international entity for the purposes of asset protection, please share your thoughts about related bank accounts, either domestically or internationally.
Sure. So an international entity, whether it's a trust, an LLC, et cetera, can own assets, no different than a domestic entity. It can own international bank accounts. More than likely, it can own domestic bank accounts. Just depends on the financial institution. Understand that a lot of times people will set up an international entity. They don't necessarily send their assets there. They might keep it open for 1, 2, 3, 4, 5 years and then send their assets there. So it's not like you have to send them there immediately. With this being said, and as we've talked about before, you always need to make sure you're as proactive as possible. You don't want to try and send your assets there after the fact. When you are sending assets there, the international entity will give you protection. However, if you still custody your assets, your bank account, your stocks or bonds, at a U.S. bank, there's not going to be as much as protection because although the trust or LLC is international, the asset is still U.S. based, which will allow a judge to get a hold of it. Further, even if you have an international trust and it holds, stocks or bonds, because those stocks or bonds are domestic, again, a judge could potentially get a hold of it. Not nearly as easy as he could if you owned it or a domestic entity, but there's still the could. So again, when I have a client that's looking for maximum asset protection and they set up an international entity, I like them to use international banks that don't have domestic ties. That way, a U.S. judge has no jurisdiction over the trust, the LLC, the entity, and the judge has no jurisdiction over the asset. And if the client wants to invest in assets, well, they can keep it in U.S. dollars. They can put it in euros and pounds, Swiss francs. I mean, they could change currencies, and they can also invest in international investments. However, if you keep your money domestically and/or domestic investments like a stock or a bond, there's still some leeway for a court or a judge to get to it. So I like to keep the assets international without the U.S. ties.
Thank you. Just a couple more questions before we wrap up. And you might have answered this, but can personal bank accounts and business bank accounts be protected? What's the best way to do that?
Absolutely. Pretty much any asset can be protected, and there's different strategies for the personal and the business side, but similar concept. I mean, on the personal side, if you own the bank accounts in your personal name and you're sued, you can lose them. So, we'll want to use some sort of protective entity to own those bank accounts rather than the individual owning them in their personal name. So that way, if they're in a separate entity and you get sued personally, now no one can, it's not an asset of yours, no one can go after your personal bank accounts. No different with the business. If the business is sued, they can go after any of the assets within the business. So you'll want to, limit the amount of, cash that you keep in the business. And for companies that do have to keep cash in their business, whether it be bonding requirements or construction companies or just a business that requires a lot of capital, there's certain strategies that we can, implement using different protective entities where you can, separate the cash from the operating business directly. And that way, if the operating business gets sued, all the cash is not sitting in there.
Okay, thanks. And what about if someone has each location or a separate business as a separate LLC and then has like a parent company that's an S corp? What happens in that situation?
Yeah, so the important thing to think about there is that, the holding company, number one, is protected because if that holding company gets, if the holding company ever gets sued, so what we see a mistake a lot of people will do is that parent company will be an operating business, so you want to make sure that that's protected. But separating the locations is great. It keeps, any liabilities from one location separate from another location. And again, making sure that the entire team is working together from a tax and asset protection standpoint is really, really important because the S corp situation you'll have to make sure that it's not a taxable event taking any assets out. There's no tax consequences in terms of separating the different locations, and that everything is flowing through one S corp tax return.
But I'll add there, what they really are going to need to do is they've taken a great first step by separating the businesses. But please note, because the holding company is an S corp, if the client is sued personally, the creditor could take the shares in the S corp and then take all the underlying businesses. So while the client with this question did an unbelievable job of separating the businesses, the client needs to now protect the shares in the S company. And there's different ways that the S company shares can be protected. It's too long to get into now. There's special trusts that can own the S corp shares. There's special LLCs that can own the S corp shares. But the client needs to make sure that they protect the shares in the S corp.
Okay, that's very helpful. Thank you so much. So I want to thank everyone for joining us today, and thank you for sharing your insights, Ariel and Hillel. If you'd like to contact them for a complimentary consultation, please reach out by email. We had shared that previously, info@assetprotectionattorneys.com, or you can call the phone number here on the screen, 561-953-1050. So that is a complimentary consultation, and I definitely think that that's a great thing to take advantage of, as so many things seem to vary by state, and they've got a lot of expertise and resources for you. And if you'd like a copy of the books by Hillel, we're going to have a poll in just 1 minute. Just click yes in the poll, and they'll reach out to you by email to get your mailing address. So it's these two publications, Financial Self-Defense and Asset Protection Secrets. And so let's launch that poll so you can select if you would like to have the books sent to you. We're not going to share the results of that, but we'll just capture your information so that we can reach out to you. So thank you everyone on the line for joining us today. That was a lot of great information that's probably got you thinking and wanting to explore more how you can protect your business. We will share the recording of today's webinar with you within 24 hours via email. And for our Vistage members, please be on the lookout for upcoming webinars in our Leading in Challenging Times series. We'll have the opportunity to attend an exclusive webinar next week with the U.S. Chamber of Commerce to learn about the latest in small business policy. I know that's making a lot of headlines and been monitoring that. And I think during the course of the call, saw that the CARES Act bill was passed. So that's excellent. So watch for that registration link in your email. And thank you all for your time, Ariel, Hillel, and everyone who attended. And please be well.